Okay, so this is Tractate Shevuot, Daf 46, and tonight we're going to study for the Ilui Nishmat of, hopefully I can say his name right, but Fransisco Orellana. Okay, so both the first clause and the latter clause address cases in which proof is required, as even in the first clause, the worker must have witnesses testifying that he was actually hired. The Baraita does not mention it because it teaches only with regard to proof that requires the employer to pay, but it does not teach with regard to proof that makes it possible for the worker to take an oath and receive payment. Rabbi Yirmiyah bar Abba said, after Rav's death, the sages sent the following message to Shmuel from the study hall of Rav. Our teacher, instruct us with regard to the case where the craftsman says, you fixed 2 coins as my payment, and the other, the employer says, I fixed only 1 coin as your payment. Who takes an oath? Shmuel told them, in that case, the employer shall take an oath to support his claim, and the craftsman shall lose the difference. With regard to fixing of the wages, people certainly remember. The sages instituted the oath taken by the worker, where he claims he has not been paid in a situation where it is reasonable to presume that the employer is distracted and apt to forget. The Gemara asks, is that so? But doesn't Rabba bar Shmuel teach in a Baraita, if there is a dispute with regard to the sum fixed as wages, the burden of proof rests upon the claimant, that is, the craftsman. If he does not bring proof, his claim is dismissed. The Gemara clarifies the difficulty. Why? Have the employer take an oath, and only then shall the craftsman lose the difference, in accordance with Shmuel's ruling. Rav Nachman said Shmuel teaches the Baraita disjunctively. Either the craftsman brings proof and receives the amount he claims, or the employer takes an oath and the craftsman loses the difference. The Gemara raised an objection to Shmuel's ruling from a Baraita with regard to one who gives his cloak to a craftsman for mending, and then the craftsman says, you fixed 2 dinars as my payment, and that one, the owner, says, I fixed only 1 dinar as your payment. Then so long as it is so that the cloak is in the possession of the craftsman, it is incumbent upon the owner to bring proof that the fee was 1 dinar. If the craftsman gave the cloak back to him, then there are 2 scenarios. If the cloak is lodged in its proper time, on the day of the cloak's return, then the craftsman takes an oath and receives the 2 dinars. But if its proper time passed, then the burden of proof rests upon the claimant, and the craftsman would need to bring proof that the fee was 2 dinars. The Gemara states the objection. In any event, the Baraita states that if the claim is lodged in its proper time, and the craftsman takes an oath and receives his payment, according to Shmuel's ruling, why should this be so? The employer should take an oath, and the craftsman should lose the difference. Rav Nachman bar Yitzchak said in response, in accordance with whose opinion is this Baraita? It is in accordance with the opinion of Rabbi Yehuda, who says, any time that the basic obligation to take an oath is directed at the employer, as in this case, as he admits to part of the claim, the sages instituted that the obligation to take the oath is transferred, and the hired worker takes an oath and receives his payment. But according to the opinion of the rabbis, the employer takes an oath and is exempt, as Shmuel ruled. The Gemara asks, to which statement of Rabbi Yehuda is Rav Nachman bar Yitzchak referring? If we say he is referring to the opinion of Rabbi Yehuda in the Mishnah, 44b, how can that be? There he is being stringent and restricts the cases where the worker takes an oath and receives payment. So, more so than the rabbis, as we learned in the Mishnah, Rabbi Yehuda says the worker does not take an oath and receive payment without any other proof unless there is a partial admission on the part of the employer with regard to payment of the wages. Rather, he's referring to the opinion of Rabbi Yehuda in a Baraita as it is taught, a hired worker, as long as the time allotted for him to receive his wages has not passed, takes an oath and receives payment of his claim. And if not, the time has passed, that is, he does not take an oath and receive payment. Rabbi Yehuda said, when does the worker take such an oath? It is in a situation when he said to his employer, give me my wages of 50 silver dinars, which are still in your possession, and the employer says, you have already received a golden dinar, equal to 25 silver dinars from them. Alternatively, the worker said to him, you fixed 2 coins as my payment. The other, the employer says, I fixed only one coin as your payment. The Braita continues. If the employer said to him, I never hired you, or he said to him, I hired you but gave you your wages, the burden of proof rests upon the claimant, the worker. Rabbi Yehuda rules that it is only when they disagree about the amount of wages owed to the worker that the worker takes an oath and is paid his claim by his employer. So Rav Shesha, son of Rav Idi, objects to this. But is this Braita, which says that the craftsman can take an oath about the sum fixed as the price, the opinion of only Rabbi Yehuda and not that of the rabbis, meaning the majority? Now, where Rabbi Yehuda is stringent and restricts the opportunities of the worker to take an oath and receive payment in the Mishnah, the rabbis are lenient, granting the worker the right to take an oath as proof that he has not been paid. Then, in a case where Rabbi Yehuda is lenient, in a dispute described in the Braita concerning the amount fixed as wages, granting the worker the right to take an oath as proof of his claim, would the rabbis be stringent with regard to the worker and grant the employer the right to take an oath and be exempt? The Gemara wonders, rather, what can be said that the Braita is in accordance with the opinion of the rabbis, meaning the majority? But if so, then with regard to that Braita that Rabba Bar Shemuel teaches, that in a dispute about the sum fixed for the craftsman's wages, the burden of proof rests upon the claimant, whose opinion is it? It is not the opinion of Rabbi Yehuda and not that of the rabbis. According to Rabbi Yehuda, the craftsman takes an oath to prove his claim about the wage, and according to the rabbis, it is the employer who must take an oath to exempt himself from paying the higher wage. Rather, Rava said that they disagree about this. Rabbi Yehuda holds that only in the case of an oath mandated by Torah law do the sages institute an ordinance for the benefit of the hired worker, that he can take an oath to support his claim. When the employer's claim contains an admission to part of the claim of the worker, the employer is required by Torah law to take an oath to support his claim. But with regard to an oath mandated by rabbinic law, such as where the employer denies owing any money, where according to Shmuel he still must take an oath, the original oath is already an ordinance, and we do not institute an ordinance to adjust an already instituted ordinance. And the rabbis hold that with regard to an oath mandated by rabbinic law, we also institute an ordinance for the benefit of the hired worker. But with regard to the dispute about the fixed wages, they maintain that the employer will remember the amount, and therefore he takes the oath and is exempt. As Shmuel ruled. According to Rabbi Yehuda, the worker takes the oath in that case, as the employer admits to part of the claim, and the sages transfer the oath to the worker as the means by which he can prove his claim. Rav Shesha's objection is therefore not valid. The difference between Rabbi Yehuda and the rabbis is not that Rabbi Yehuda is more stringent, rather it relates to the circumstances under which they see fit to have the worker take the oath. So the Mishnah teaches, how does the halacha of the worker taking an oath and receiving payment apply to one who was robbed? The case is where witnesses testified about the defendant that he entered the claimant's house to seize collateral from him without the authority to do so. The claimant said, you took items that belonged to me, and the defendant said, I did not take them. The claimant takes an oath and receives payment of his claim. The Gemara challenges, perhaps he did not seize anything as collateral from him. The witnesses testify only to the fact that he entered the house for that purpose. Doesn't Rav Nachman say with regard to one who takes an axe in his hand and says, I will go and chop down so-and-so's palm tree, and the palm tree is found chopped down and tossed on the ground? We do not say that he chopped it down, but rather we search for evidence. Okay. Evidently, a person is prone to bluster without acting on his threat. Here also, it could be that he was blustering about seizing collateral but did not act on it. The Gemara answers, say that the case in the Mishnah is where the witnesses testify that he entered the house and seized collateral from him. The Gemara asks, if so, let us ask the witnesses and see what items he seized as collateral from him, and there will be no need for an oath. Rabbi Bar Chana said that Rabbi Yochanan said, this is a case where one claims that the defendant took items that can be carried beneath his garments, and the witnesses could not see what they were. Rav Yehuda says concerning a similar topic, if witnesses saw a person who entered another's house, concealed items beneath his garment and left, and then that person says they were purchased, and that is why they are in my possession, he is not deemed credible. And we said this only with regard to items taken from a homeowner who is not apt to sell his items, but with regard to a homeowner who is apt to sell his items, the one taking the items is deemed credible. And even with regard to a homeowner who is not apt to sell his items, we said that the one carrying the items is not deemed credible, only with regard to items that are not typically concealed. But with regard to items that are typically concealed, he is deemed credible. And even with regard to items that are not typically concealed, we said that he is not deemed credible, only with regard to a person who is not generally secretive, but with regard to a person who is generally secretive. That is his manner. He would be likely to conceal items beneath his clothing, and he is deemed credible. And we said this only when this one, the homeowner, says the items are borrowed, and that one who took the items says they are purchased. But in a case where the homeowner claims that the items are stolen, it is not in his power to have his accusation accepted, as we do not presume a person to be a thief. Furthermore, we said that the one who claims he purchased the items is not deemed credible only with regard to items that are typically lent or rented, where the homeowners claim that they must now be returned is more reasonable. But for items that are not typically lent or rented, the person who took them is deemed credible. As Rav Huna bar Avin sent a ruling to the sages, with regard to items that are typically lent or rented that someone took and said they were purchased, and that is why they are in my possession, he is not deemed credible. This is like that incident where Rava ruled to expropriate fabric scissors in a book of Agada from orphans whose father had taken them, as they were items that are typically lent, or rented. Okay, the oath of one who is robbed can be taken by others as well. Rava says even a watchman at the house can take the oath, and even the wife of the watchman can take the oath. So Rav Papa asked, with regard to the employer's regular hired worker or his regular harvester who are not appointed to safeguard the employer's property, what is the halacha? The Gemara responds, the question shall stand unresolved. So Rav Yamar said to Rav Ashi, if one states a claim against another that he left his house with a silver cup and is liable to return it, what is the halacha? Rav Ashi replied, we see if the owner of the house is an affluent person, or if he is a trustworthy person with whom people deposit their valuables, as those are people who would typically have a silver cup. If the homeowner is in these categories, he takes an oath and receives payment of his claim. But if he is not, he does not receive benefit of taking an oath in order to prove his claim. The Mishnah teaches, how does the halacha apply to one who was injured? If witnesses testified about the injured person that he entered into the domain of the defendant whole but left injured, the injured party may take an oath and receive compensation. Rav Yehuda says that Shmuel says the sages taught that he needs to take an oath in order to receive compensation only if he was injured in a place where he is able to injure himself. But if he was injured in a place where he is unable to injure himself, he receives compensation without taking an oath. The Gemara challenges, and let us be concerned that perhaps he scraped against a wall and caused the injury himself. The Gemara explains, Rabbi Chia teaches that the Mishnah is referring to a case where, for example, he has a bite on his back or on his elbows, which must have been caused by someone else. The Gemara challenges, and perhaps a different person did it to him, and not the defendant. The Gemara explains, this is a case where there is no other person with him besides the defendant. The Mishnah teaches, how does this halakha apply to one whose opposing litigant is suspect with regard to taking of an oath and therefore is not permitted to take the oath? One is suspected if he had been found to have taken a false oath, whether it was an oath of testimony or an oath on a deposit which was prescribed by Torah law, or even an oath taken in vain. The Gemara asks, for what reason does the Mishnah emphasize even an oath taken in vain? The Gemara explains the Mishnah is speaking utilizing the style of, it is not necessary So it is not necessary to state that one who is suspected of falsifying these oaths is disqualified from taking oaths, as they entail the denial of a monetary claim. Due to the false oath, someone incurs financial loss, but it is necessary to state that even that oath, an oath taken in vain, which involves merely the repudiation of one's verbal commitment, nevertheless grants one the status of a person who is not credible and who is disqualified from taking oaths. The Gemara suggests, let the Tana also teach that falsifying an oath on an utterance, which is also an oath without monetary consequences, disqualifies one from taking oaths. The Gemara responds, when the Tana teaches which types of false oaths disqualify a person, it includes only oaths with regard to which, when one takes the oath, he is at that time falsely taking the oath. But with regard to an oath on an utterance, such as an oath that he will eat a specific fruit that day, where it can be said that he took the oath with true intention and intended to eat that fruit, but ultimately failed to do so, the Tana does not teach as one who does not fulfill such an oath retains his credibility to take oaths, since he did not conspicuously lie. The Gemara raises a difficulty. It works out well to make this distinction for one who is liable for an oath on an utterance like I will eat or I will not eat. Where is it possible that he was not lying when he took the oath? But with regard to oaths about the past, like I ate or I did not eat, what can be said, since he certainly took a false oath? The Gemara answers, teach the Mishnah, that is, understand it to mean, an oath taken in vain, and that's the end of 46.